Good afternoon, everyone. Thank you very much for coming. So apologies for the shift to week 8, which was because the rooms here were all in use last week. So especially for those of you who crawled out of your essay writing rabbit holes, it's good to see you. We are confronted by living proof that there is flourishing life after an MSc and DPhil in the centre. So it's my great pleasure to welcome Richard Martin, who is a graduate of this place. He now works in the law school at LSE at the intersection of criminal justice, human rights, policing, public law. His first book, Policing Human Rights, was one of the best books on law and policing that I've read in a long, long time. And he's going to talk about that theme.
There's not many of them.
But if it's a small pool, you still want to be in the... and he's going to talk to us on that theme today, on the intriguing, unusual prospects of law actually changing something in the world of policing. So I'm intrigued to know what that's going to look like, and the floor is yours.
Thank you, Ian. I'm flattered to be back. The centre's given me that professionally, personally. Little did I know 10 years ago that I would be in Oxford for another 10 years, and that my future wife would be in the audience. I was a bright-eyed MSc student, so there you go. A sustained interest of mine is the relationship between law, policing, how officers make sense of the part. And I'm really pleased to be giving this paper here in Oxford, because the paper is coming home in a way. It began towards the end of the PhD, when anything looks more interesting than your own project. And I was chatting with a police officer in the Missing Bean, no less, and I was curious because I was writing a couple of chapters on police custody, police detention, and a routine police bar, which is pre-charge bail. It's during police investigation. It enables police to release suspects with a time frame in mind. So the suspect has to come back to the police station, and often conditions are attached to those bail conditions, or conditions attached to that release bar. And Theresa May decided, for reasons that we'll look at, she wanted to heavily regulate this part that had really not been on the political or really legal radar at all. It seemed to be very much led by her in the Home Office, put a time limit on the power, new authorization thresholds and process that had to be met, and a presumption that the power actually wouldn't be used. I was speaking to the police officer, and he said, "Yeah, we just don't use it anymore." I said, "What do you mean you just don't use it anymore?" I said, that doesn't make any sense when you reverse the law and policing literature. But he said, "Yeah, overnight we just stopped using it. Total retreat." So my research antenna stood up at that point, and I thought there's got to be a project in this. So I approached a large police force in England and Wales, and I said, "Is this indeed happening? Would you be interested in trying to make sense of it?" And they're great. They said, "Yes, let's work together. Let's devise a project to see what's going on here," because there were real concerns about the implications of this. So what I want to do today is share some of the initial findings from that research and explain why, because of subsequent developments, that project has grown into a more ambitious and longer-term project because of subsequent changes in the law that were born out of the very issues that the research project shows up. Together, these findings show that law did change policing in exaggerated and unexpected ways. But the question is, how did it do so? What were the so-called, in David Dixon's terms, conjunctural circumstances of contemporary policing that might explain why this was so? And indeed, does this case study require us to reevaluate some of the truisms on which criminological wisdom about law and policing seems to rest? And as I said in the abstract, in answering this question, my modest endeavour really is to try and inject some verve into a well-trodden body of research in which legal cynicism really abounds. But doing so within the scholarship is not, I want to suggest, a straightforward task. It's not straightforward, in part because the findings here appear to question some, but certainly not all of this wisdom that makes me immediately sceptical. But it's also because what was once a lively field of study has, I think, ironically shrunk in the last 2 decades, despite law reform continuing apace. The classic law in policing literature's truisms, I think, must be exposed to and their insights critiqued and claims reappraised in the contemporary context of policing law and regulation. 2024 is not 1984 when PACE was first enacted, yet it's the PACE studies that have defined the field and continue to define the field. Police work in an era of demands of greater professionalism, accountability, and ones in which the paradigms of risk management, but also human rights have gained particular prominence. So what I want to do is look at some of these truisms. I want to look at 3 works that I think marked the high watermark of law and policing scholarship, that just as the sun was setting on this body of work, there was books that suggest that there should be a new dawn of this research, and I don't think that that's ever really taken place. So I want to take some things from that research and suggest that it sets up a really nice framework for looking at contemporary law and policing. And then in the second half, I want to get into the case study and explore that conceptual framework that I think we can take from the high water point of that work. So these are the responses that I think you would get if you were to have a conversation with the law and policing scholarship. That scholarship was masterfully reviewed by David Dixon 25 years ago, looking at the work from the 1960s to the 1990s, end of the 1990s, in his book Law and Policing. And he surveys 3 theories, looking at 2 in particular that were influential in setting out the dynamics between law and policing. And he focused in particular on culturalist theories and structuralist theories. I'm not going to go through all those all. He does it really well in real detail and with a really nice critical edge to it. But what I do think we can do is extract some truisms from that are helpful kind of consolidatory task based on some of going back to some of those works myself. And across these series, I think we hear repeated these kind of truisms, this kind of cynicism about lost capacity, indeed motivation to regulate police work. Albeit the points of emphasis in the empirical projects that made up that work is diverse. Some of it is coming from sociology of policing in the 1960s, patrol work, detectives in the US. Some of that work is coming from England and Wales, the PACE projects, as they were known by McColville, Sanders, Lang, David Dixon, and McBarnett's work, Conviction, Law State, and Construction of Justice. So with that caveat, these are, I think, some of the truisms. The first one is that legal rules cannot explain police behavior or decision-making because the law is only loosely connected with the very function of the police in the first place. We know police don't spend most of their time enforcing the law. It's about order making, it's providing provisional solutions to everyday ruptures to the social order. General order, specific order, familiar terms in the policing scholarship. Captured, of course, in the work of Egon Bittner. The special competence of police is that force might be required, provisional solutions to something that ought not to be happening, about which someone had better do something now. Law enforcement being very much in the background of that. Brown's work from 1981 in the US makes very clear as well that the decisions to arrest, to detain someone were rarely made on the basis of legal considerations. He talks about achieving objectives unrelated to the law, personal pressures, personal values of the officer, the need to maintain respect for police authority, the attitude test, etc. Another truism, working in low visibility and wielding significant power, officers can choose when and how to deploy legal rules. A common theme in studies of street policing, but also detective work, is the low visibility of police actions, of decisions. Richard Erickson's work back in 1981 on detectives describes how a major resource of the detective is the fact that many of their actions are not legally or practically open to re-examination, creating what he describes as a visibility cover. And thus a detective's decision to construct a matter in a particular way has to be accepted at face value by other members because there are rarely the means or the inclination to otherwise. This work has also looked at the degree of control that the police have in situational context in which the law is actually applied. So when it comes to criminal investigations, case construction and police custody, the Conville, Sanders and Lang's, the case for the prosecution is the work here showing how police are very much in control. They don't have to account to anyone in any real sense, according to them, for the rules which purport to control and inform their behaviour. The police station is police property. They are the chiefs of that domain. There's also a link here with the doctrine of constabulary independence, the English legal tradition of the office of the constable. When organised police forces were established in the 19th century, they were grafted onto the traditional office, a creation of the common law. Constable holds an independent office under the Crown and is only responsible to the law, not to their organisational superiors. This is what Luce Gordon, writing in the 1980s, described as the individualist fallacy. The officer is a self-directed decision maker, answerable to civil law, criminal law, but generally the courts will stay well clear in any event. Another truism: if officers do rely on the law, it's most often to justify, not condition or guide routine work. Law is a resource to manage workplace demands, colleagues' expectations, and ultimately avoid trouble, in the words of Chatterton. And a book that displays this brilliantly, I think, is Tank Waddington's Liberty and Order, looking at public order legislation and ethnography of public order legislation in 1990s central London. And he focuses on how public order commanders were, again, trying to control events in a precarious environment. And the law here was really of little assistance. It was rarely mentioned. It risked alienating the organisers who the police were trying to get on their side. That it frustrated the air of friendliness and cooperation in which, in Tank Waddington's words, the right to protest were being neutered very softly by the velvet glove of police negotiations behind the scenes. Law wasn't helpful in that environment, and in fact, officers' reluctance to engage with their statutory powers reflected uncertainty as to what those powers actually were, the precise meaning and application of the legislation itself. So avoiding on-the-job trouble as well. Within this truism, there's also the idea that law functions as a legitimation device, a presentational rules. They provide a framework to formulate and legitimize action and accounts. Again, McConville, Sanders, and Lang. In compiling custody records, refuse charge books, search records, and the like, the police have an unchallenged opportunity to construct reality. They describe how custody officers' mastery over records provides a cover for failure of duty, trickery, and deceit. Another truism: in some cases, this justification is made possible because the law itself governing police work is vague, permissive, discretionary. And this is in part because police have lobbied to ensure it was that way. Doreen McBarnett's work, the classic line, due process is for crime control. She examines the nature of law itself. And for her, the law provides a flexible, permissive structure within which police work can be conducted. Again, McConville, Sanders, and Lang in their work explain how a great deal of police practice is perfectly lawful because the law affords police extensive discretion, essentially enabling through open textured thresholds, terms, standards. And finally, the regulatory potential of law is stymied by the countervailing influence of informal working rules, cultural traits, and organizational constraints. Pick up more or less any work on police culture and you'll see some reference to the culture as devaluing rules, that effective police work can't be done according to legal procedures, solidarity amongst officers, demand for loyalty that precludes the kind of second guessing of another officer's decision. So I think when I look at this work, I'm really struck because I realized that this was kind of as good as it got now. I struggled to see an awful lot over the last 20, 30 years that is tremendously interested in this. So my sense is that the sun really was setting when these three big books were being written, in hindsight, on what was a lively, empirically grounded, theoretically diverse field. David Dixon, writing at the time, said the impact of PACE is one of the most, the Police and Criminal Evidence Act, regulating police detention, arrest, stop and search, was, he says, one of the most controversial issues in British criminology. And I think the irony is that some was setting as three books were signaling the very need for a new dawn in law and policing research. The first, David Dixon himself, Law and Policing, he sets up a strong methodological critique of some of the works that I've just been mentioning, on which this criminological wisdom and growing network that was based, but also with this growing recognition, actually, that the law could and did regulate police practices in particular ways. So his critique turns on the significant areas of police work that just weren't being studied. So the focus in particular on police custody, police detention, on street policing, but not a lot on office powers beyond street policing, in part because perhaps they weren't as productive or as enjoyable to research. They were harder to get access to, so detective work, disclosure, covert policing, aspects of public order policing, increasingly now data retention and privacy issues around disclosing material, retaining material, gathering material. He also notes in particular how there is very little on how police actually learn and understand the law, how the law is communicated to police, how they're informed about legal change, the provision of information, but also its actual communication within the police. And he also critiques some of the cultural accounts as focusing too much on culture and not the individual agency of officers. And then he concludes in conclusion, he comes back to a point which I think is also a kind of critique, but he notes that there's very little to be said about what at the time was called new public law, positive state regulation. He said that there seemed to be very little crossover between public law and criminal justice, and the idea that actually law goes beyond civil procedure and criminal procedure, but there's a whole field of administrative law that really doesn't feature in a lot of that work. And that it itself was only really developing from the 60s, 70s, and it was really not until the 80s that we were getting a clear sense of the grounds for judicial review themselves. He also stresses the contingency of law in policing. How the law's relationship with policing depends on the nature of the law, the type of policing, social and political contexts. That law doesn't have some fixed essence. It's an adaptable set of practices, discourse, techniques, modes of regulation. It can be both broad, discretionary, but it can also be rule-based in a clear sense. He also suggests the need for theoretically based empirical work, which explores, in his words, the conjunctural circumstance, the combination of things happening at the same time in which a law appears in particular forms, without slipping into kind of legal imperialism in which everything is seen through the lens of law and what he describes as lawyers' claim to hegemony. The second work is a piece that isn't, I don't see referenced very much at all, but I think is full of gems, and that's Neil Walker's Policing in the Changing Constitutional Order. And he talks about how the prominence of the doctrine of constabulary independence, with its focus on the legal autonomy of the individual officer, has obscured awareness of the different types of decision-making that take place in policing, contributing to, in his words, a general understatement of the law's potential in the debate about how law enforcement policy is and not to be made. Two things in particular about this book that I think are significant. First is the focus on the indirect effect that the law can have. Talks about where law does have a role, it's often indirect and facultative. It's taking place under some conditions, but not others. It takes several steps to trace what the law is doing. In particular, he said he identifies how the law can play a role in setting out the mechanics of policy making and policy monitoring, and in establishing internal structure and powers of agencies involved. This is getting close to the realm of administrative law. He also draws attention and helpfully revitalizes aspects of Robert Ryder's typology of police decisions that was tucked away in a small pamphlet, a small report in 1993. And Walker emphasizes the real analytical value of that typology to illuminate the limited and differentiated rule of law as a means of shaping policing. And this is the typology here, very straightforward. It doesn't take much to I think the lack of reflection on different types of decision making, it doesn't take much to add something at this point. The questions, the axes are, do they relate to a general type of case or a specific concrete case? Do they concern internal organizational matters or law enforcement? Linking in with Walker's idea that actually the law can affect internal issues of housekeeping, of resource distribution, of setting up internal mechanisms of accountability and review, policing styles in terms of the policy police adopt, whether it's a non-arrest policy or arrest policy for domestic abuse or something like that. And then obviously a lot of the attention focuses on the actual individual cases and how officers are exercising these powers, policies, tempered by internal organizational issues in the concrete circumstances of a case. I'm going to come back to this. But also the political choices that are at play in policing styles and housekeeping. The idea that there's an essence of public choice and that this kind of middle management space, there's a lot happening as well as individual cases. And then we have Richard Erickson and Kevin Haggerty's Policing the Risk of Society, which many of you are probably familiar with, a significant book in the field of policing and beyond. They claim that both policing and the society in which it takes place are best understood in terms of a paradigm of risk. In a risk society, they say, policing is not just a matter of repressive, punitive, deterrent measures to control those who are morally wrong. It is also a matter of surveillance, of producing knowledge of populations that is useful for administering them. What I'm most interested in this book is how they turn to the administrative apparatus of policing the risk society. This part of the book studies how the police perceive and handle risk communications internally. It's a study, they say, of police bureaucratization. How the elaboration of a rule system is the result of new accountability requirements and the knowledge work associated with them. Two major pieces I found useful in this book. The first was an empirical finding that there is indeed a considerable amount of accountability demands from sources external to the police, including legal demands for police procedural propriety. He describes how the research literature has exaggerated the low visibility of police work. It suggests that police officers have a repertoire of covert and manipulative devices to keep knowledge from others. But their research shows how officers, the research shows how these earlier works have perhaps neglected how communication rules, formats, technologies make officers more visible to police supervisors and managers and to external institutions for whom relevant knowledge is routinely produced. And they give us in the book some really helpful conceptual apparatus to start building that account. Communication systems, communication rules, communication formats in which those rules are translated through. And my sense of the state of play is that I'm not sure that this project and these ideas that were left for us in these books in the late 1990s have been taken up with any great enthusiasm or sustained inquiry. We've got a handful of studies on the Regulatory Investigative Powers Act 2000 that governs covert policing. The focus there really is on covert policing and culture of policing and the practices associated with that, albeit this regulatory domain is in the background, but not the foreground of that work. We have some really excellent books on law and policing, but again, they are classic street policing, or right in the heart of police detention and custody, again, in which Lena Skin's work is great, but the law is around the side of it rather than foregrounded in looking at that kind of unpacking of the organizational communication formats rules, etc. And I think that this, I'm going to go over this a bit more quickly, but I think that this becomes especially problematic because not only have we not continued in the spirit of some of those works, but contemporary policing and regulation is in an area of greater professionalism, greater accountability, which risk management, human rights have gained more prominence, whether the kinds of calls for more visibility, more accounting, more reasoned administration, much more so than when Erickson and Haggerty were writing. And in particular, I think we have to get to grips with administrative law as part of the police force. The body of law governs the organisation and the activities of administrative agencies. How law gives powers, duties, rules that must be applied, decision-making processes. So I won't go into these, but generally we've had Human Rights Act with a series a general duty that makes it unlawful for the police as a public authority not to comply with a whole series now of increasingly detailed rules and principles, from how investigations take place, how public order policing takes place, how covert investigations take place, the Equality Act, and huge areas, data protection, given the amount of private information protected by Article 8 of the European Convention on Human Rights when it comes really sensitive information that police hold, that they gather, they retain, they use. And there's a whole series of very specific legislative schemes that govern these areas now, one of which I'm going to talk about shortly in the context of pre-charge bail. So in one sense, we've got an extensive statutory provisions that empower but also regulate policing. We've got a lot of these concerned with and framed around the paradigm of human rights law, with the notions of necessity and proportionality being a key kind of language there, operating principles there, identifying legitimate aim, ensuring that the means you use to pursue that are rationally collected, that other less intrusive means have been considered, that actually you're striking a fair balance between the rights that you're interfering with in order to gain something on the other side of the scales in terms of public protection or respecting others' rights. So writ large through police powers now aren't reasonableness, it's necessity and proportionality you see in various guises. It's the go-to legal strap that is put on a lot of powers. And that's linked to a far bigger idea in public law, the culture of justification, the idea that the state exercising power should be fully justified, it should be explained, it should be communicated, in its sense that even those that might disagree with the outcome can reasonably accept the legitimacy of that process. The idea that losers in the majoritarian legislative outcome should still be considered in general provisions application to a set of facts. And again, this links to a bigger idea within administrative law. Jerry Mashaw in the US writes of the increase now of reasoned administration, the idea that legitimacy flows from the transparent revelation of agencies' reasoning process, that this process is based on consideration of competing values, that administrative competence is demonstrated by cogent reason giving. And then finally is the proximity to judicial review, which pulls this together. We have, in the words of Bentham and others, a big chambers in London, number 5, Essex, that do a lot of police work, surveying a whole series of judicial reviews now, and saying that, noting how a significant number of challenges to the exercise of police power are by way of claims of judicial review. They're administrative, they're relying on these legal provisions of administrative law rather than purely private law claims for damages or exclusion of evidence at trials. And in the paper that I'm building on, the chapter I'm building on, I explore these themes through investigations and prosecutions, data retention, and the use of information on police databases, and the extraction of information from electronic devices, in which you see these various areas of administrative law coming together. In all of those areas, necessity and proportionality are the go-to concepts to structure police thought, police power, police justifications. And often there is a requirement to record decision making, to be able to have a rationale for that. So when I pull all that together, conceptually, and these empirical developments, this is the typology I think that we come to arrive at that makes more sense of what's going on, that I'm sitting in the middle of. But what struck me is it was odd in this typology to talk about the indirect and facultative roles that law can play and not have law in the typology somewhere. So it seems to me that we need legislation and the legal sources from the outset, or we risk this blind spot coming about again. But it also struck me that to talk about internal organization and housekeeping, allocation, housekeeping is where we go with it, misses this notion of communication systems, of reporting requirements, communication rules, formats, technologies, and the actual engagement with that notion of reasoned administration, the engagement with the paper burden that comes with this. But I've strapped on this column and this row to try and give a fuller account, I think, in light of those books and in light of the developments. And what I want to do is now apply that typology to the case study and see if we can make sense of the changes that have taken place in this particular police bar, which is pre-charge bail. And this would appear to unsettle the criminological wisdom, the truisms, I think, up to a point, because law did change policing in really exaggerated and unexpected ways. So briefly on the background of pre-charge bail, bail occurs during the investigative process. It enables police to release a person who has yet to be charged, but the police are continuing that investigation, considering whether or not to charge. It's an alternative either to being remanded in custody or to just walking free from the police station with no controls whatsoever. The custody officer can place bail conditions on a person. These can include conditions to live at a fixed address, to report to a local police station several times a week, for example, to obey a curfew, to avoid contact with named people or places, even to surrender a passport. So akin to court bail after charge. Crucially, police bail, a breach of police bail conditions is not an offence, but you can be arrested and detained in custody, where the breach can be recorded, and the police can decide if they are then going to progress the investigation at that point or release again. As summarised by Ed Cape and Edwards, police bail is a classic example. Was a classic example of a low-level, broad, discretionary power, which was largely uncontrolled. It was a firmly entrenched and routine feature of police investigations, and as Cape suggests, it reflected investigative convenience rather than a means of maximising liberty, as it was first intended as an alternative to custody. But no, that was at a time, 1925, when this bar was first created. It was at a time when arrests would come very late on in police investigation. No arrests happen very early on in police investigation as a means of initial evidence gathering. Why did they describe it as largely uncontrolled? It was largely uncontrolled. First of all, the two main provisions of PACE that allowed a person to be released under pre-charge bail were silent on whether They had no criteria to release on bail in the first place. There was some criteria that the conditions needed to be necessary for defined purposes, but there was no obligation on the officer to have regard for the seriousness of the suspected offence, no sense of proportionality, and even thinking about a bail, use of bail power. Even where bail was unconditional, where it didn't have conditions attached, it still came with a requirement to report back to the police at a specified date and time. Where you would be rebailed often, or where a decision would be made. There's no obligation to receive representations from the suspect or their lawyer on bail. There was no obligation to take account of representations. There was no time limit on a person, on how long a person could be bailed. You had a series of rebails and rebails and rebails. There was no judicial oversight. You could challenge the conditions. You could have them varied or rescinded. But you couldn't actually challenge the decision to release you under bail rather than release you freely without that reporting requirement ultimately come back to police. Up until 2015, until about 2015, there was very limited interest in pre-charge bail at all. The Law Commission in 1999 excluded it from its review. The Home Office major consultation of police bars in 2004 simply made no reference to it. Data on the use of this bar was not routinely collated. There was no national picture of how police were using these bars to impose thousands of conditions on thousands of people, often for very lengthy periods of time, without the ability to challenge that decision. There's major controversy and reform came about from mounting pressure concerning its use. Well-known public figures, members of the press, including Paul Gamcini, Freddie Starr, and journalists arrested as part of the phone hacking scandal, made a big deal of being on pre-charge bail for a very long time, whilst forensic downloads of phones were taking place and the investigation was being processed. So this managed to exert quite a degree of influence on the Home Office, these groups. There was a joint letter by ministers, MPs, lawyers, and campaigners published in the Telegraph, critiquing how people were languishing in a form of legal limbo as they sat on these conditions for months, if not years, whilst their case rolled on and on and on. They described the mental anguish that came with this, the sort of Damocles hanging over you, waiting to know what the outcome is going to be. And Theresa May and the Home Office decided there must also be justice for those under investigation who are unable to take family holidays, make long-term plans, and are effectively putting their lives on hold. So legislative changes came about, significant ones. We had a presumption of release without bail from police stations, the emergence of a new disposal type, release under investigation, rather than unconditional bail. So you're still under investigation, but there's no conditions attached. There's no duty to come back to the police station at a certain time. The threshold for bail would now be necessary and proportionate in all the circumstances. And applicable bail periods and authorizations came into play. There was a whole new time frame. An inspector would have to authorize bail up to 28 days. From 28 days to 3 months in the investigation, it would be a superintendent, a significant jump in rank. And beyond 3 months, the magistrates came into play. So there was no judicial supervision, district judges deciding whether after 3 months somebody should still have these conditions attached. And at the time, there were real skeptics. Anthony Hucklesby, who's written a lot on court bail and police bail, said that this would not reduce police bail because it was so deeply ingrained in the cultural values and practices of police. The way that you release somebody from the police station, particularly where there's a degree of risk, was conditional bail. You put some kind of conditions on them. It provided police with assurances they could track people down. They had some degree of control over suspects. It provided reassurance to victims. And it also provided impetus for the investigation to actually be completed. So this was the project that I undertook to try and figure out what was going on at this point. I interviewed about 50 police officers in different roles. I got 4 years of custody data, 2 years before the reforms, 2 years after the reforms, to try and see what the difference in the actual use of the power was in a more detailed sense. And I also gathered 500 of these authorization forms to actually see how the police were justifying engaging in this kind of reasoned administration. So what impact, descriptively, did the reforms have? So this is looking at the custody data. So we see a really sharp reduction indeed in the use of pre-charge bail in the coming into force of legislation. Police bail previously, for the 2 years before the reforms, was the disposal choice in 19% of offences. Vast majority of those, almost 70%, involved conditions attached. After the reforms, that dropped from 19% to 2% of offences released from custody. 25% of cases switched to this release under investigation. Bail disappeared, release under investigation surged. At the individual level, 2 years before, there were over 15,000 people on police bail. After the reforms, that dropped to 1,200 people on police bail.
Ricky, do you mind
Yeah.
if we just stand?
Yeah, I'm
Second. Just for a second, because
If I-
there's a
just over it,
it's a really
Yeah.
interesting graph.
So we see this reduction. If we look at it for specific offences, if being the operative, oh, there we go.
Oh, it's stuck. Layla has to
do
touch
some
it.
magic.
Okay.
Our communication format and technology.
Oh,
Okay.
Try again now.
here we go.
Excellent. Okay. So here we have it. Thank you.
What?
By specific offences. So we can see here, really significant drop in pre-charge bail, even for really serious stuff. Rape, attempted rape, GBH, sexual offences, burglary. Massive increase in release under investigation. Really significant percentage increases in these offence types being released with no conditions attached at all, no deadline to return to police statement. We also see a reduction in charge, which I'll come back to in a moment. What's especially striking was when I looked at the warning flags on the police custody data set for high-risk suspects. So these are individuals who attract warnings based on police judgment. These are recorded on the niche system. So for warning classifications of domestic abuse and child at risk, or both of which there's 52,000 offences with those warnings. Prior to the reforms, 15% of those with warnings would have been released with conditions attached. That dropped to just 3% after the reforms. So even in these cases where you would expect there to be conditions because it's a domestic abuse and child at risk, even those kinds of cases, it wasn't being pursued. Medium or high risk domestic abuse cases that were flagged, of which there are 7,000 offences in the data set. Prior to the reforms, 18% of those would have been released with bail conditions. After the reforms, just over 1% were being released with bail conditions, 26% being released under investigation. In terms of the actual time spent, so a central aim of the Home Office in promoting the statutory reform of pre-charge bail was to reduce the length of time an individual spent on bail to drive down the overall time with these conditions attached before you receive final disposal. What I found was that for the old bail system, the 2 years before the reforms, the average duration an individual spent waiting for the final disposal was 140 days. After the reforms, those that were released under investigation, so the majority that switched from bail to investigation, that increased to 254 days. So a 100-day increase after the reforms. What I found actually was that 65% of cases under the old bail system did receive an outcome within 3 months. That dropped from 65% to 26% of cases receiving an outcome on RUI within the first 3 months. So not only did bail reduce significantly, even in cases in which you might have expected it to be used, these RUI cases, released under investigation cases, were a large glut of cases in somebody's desk that were didn't have deadlines attached, weren't being processed. How on earth do we begin to make sense of this? This is why I'm coming back to, and I think I need, finally, the charge rate reduced as well. There's increase in NFAs and reduction in charges because cases where it was very tempting for officers, rather than to push for a charge decision at the point of arrest and detention, to release them under investigation. And the rates of charge for cases, understandably, that sit around for a long time reduces. So the actual charge rate was also dropping across the board. Again, this is the looking 2 years before and after effect. So I can't take into account other factors that were happening around the time, but just by stark the differences before and after, and based on the interviews, I can explain why the charge rate dropped because of officers' attitude to cases and the fact that release under investigation doesn't have timeframes to work towards. So you're not pushing the investigation. In the same way, if you were on conditional bail, you would have somebody rocking up at a police station saying, "What's happening in my case?" So trying to explain this, what I'm doing at this point is trying to take each of the rows of that typology and break down how the law and its indirect effect on policy and guidance, or direct effect on policy and guidance in some case, then goes on to function in concrete cases. So it's a tracing exercise across the table. And I think I'm beginning to make sense of it, but it feels quite formidable. So the legal test is this section 50A. It says very little at all. Custody officer is satisfied that releasing on the person on bail is necessary and proportionate in all the circumstances. And that's what officers had to work off. It was left up to police organizations to figure out what on earth that actually meant. And this is how this police service interpreted that test of necessary and proportionate in all the circumstances. Extremely high threshold, given how much legislation there is on the books to manage somebody, witness intimidation, harassment, obstructing the investigation, the need for a real and specific threat, risk, and harm. To say that organizationally there will be the resources to actually proactively police the conditions, that they are realistically enforceable. Okay, maybe that one's a bit easier. But this is a remarkably high threshold that the police set themselves. And interestingly, the rank of inspector authorizes it. The way this police force interpreted it was to also make the inspector apply the necessity and proportionality test as well as the custody officer, which created this really interesting discussion back and forth between the sergeant and the inspector, both applying a test, notwithstanding how it was constructed in the legislation for a custody officer to want to have one role in necessity and proportionality, and the inspector simply having to authorize it. But the way that this was constructed in terms of internal policy set the benchmark remarkably high. And when I spoke to officers, they described it as an edict having come down. The message from top down was, don't come and ask for it really, because these are the most serious parameters that you'll be asking for. The test of necessity and proportionality in all the circumstances, when I asked officers what that meant, quite exceptional, a last resort, unless you absolutely have to, a very extreme case, most extreme of circumstances. That's not the legal test, but that's how it had been interpreted against the political context of the Home Office saying, you've abused this power, we can't trust you, we don't trust the College of Policing to construct authorized professional practice around this. We're strapping a legal test on this, we're bringing the courts in. And the message very much to police management was, gosh, we've been burnt with this one. Let's tighten it up. And boy, did they tighten it up. There was enforcers, these custody officers and inspectors were giving out this message, we're not allowed to bail. By custody sergeants, our surgeons here in CID as well. There's a big thing about it, and they're saying, you're not allowed to use it anymore. You're covered by other offences like witness intimidation. You don't need to have bail. So it was being very much taken on by those who had the legislative responsibility to determine issues. And there's also these murmurings in the background, this context. To put some emotion in it, personally, it felt like another thing being taken away from the police. Just like stop and search, we're being told not to use our powers by the Home Office, by politicians that are having a bit of a power tussle with us in the use of our powers. They're telling us 1 minute to use them, the next minute not to. Fine, you don't want us to use them, we'll walk away from them. Let's see what happens. Do you realize the impact of what you're doing? In this sense, it was very much political. By politicians, by ministers who weren't particularly friendly or supportive of the police. So this is the second table then of the typology looking at the internal organization. And here we see the law allocating specific powers and duties and supervision. So it's set up, custody officer makes the initial decision, authorized by an inspector. You want an extension after the 28th day, you're jumping up to superintendent, then you're going to the courts. So clearly setting up powers and duties, setting up time limits, and then it's up to the police housekeeping to figure out how they are going to give effect to that. So they created a pool of authorizing officers from their inspectors that performed custody rules, they were now given the responsibility to consider bail as well. The resourcing of investigations and the capability to enforce bail conditions increasingly became an issue. Talk about in a moment, with knock-on effects again on the actual exercise of legal powers, duties, and supervision in this context. So the overarching finding is avoidance of not to go near this power anymore. Why was that? So part of it was the rank structure. It was avoiding trouble. This takes us back to law and policing scholarship. Superintendents are mythical beasts. If you tell me I've got to go and speak to a superintendent, and then you've got to go to court, it's a daunting prospect. Going back to resourcing and housekeeping, there are a huge number of very junior, inexperienced officers now, if you look at the actual composition of the workforce. So it's not surprising that somebody in your early 20s who's just started in policing as a probationary officer, the idea that you're going to jump 5 ranks to somebody who's in command of the policing area and show them your kind of not very good investigation under review isn't a very attractive option. Managing workload and deadlines. This again comes back to resourcing. It takes months and months to get a phone download, to get forensic evidence back. The time frame for an investigation is completely off the time frame of pre-charge bail and the extensions. So the officer is saying, I'm just setting myself up for a really hard time. I know I'm not going to get this evidence back for 3 to 6 months. I know from the outset I'm going to put myself in front of a magistrate's court by stemming off this process. So I'm thinking really hard, do I think the risk is high enough? And do I think it's worth the paper burden and the exposure and the visibility that's going to come with this? But again, we have to go back to the law to make sense of this too, because what we have is a case of what Jerry Maxwell calls law's underreach. The law allows this avoidance also, because if the custody officer agrees that bail isn't necessarily proportionate, it never comes before an inspector in the first place. This officer explains it really, really well. It's an odd place to be. They've injected this test around it, but if you don't make the decision, nobody will know. There's no visibility if I don't go near what's there. So I could be releasing people left, right, and centre under release under investigation when they should have been bailed. The risks are all over the place, as it seems they were, and nobody knows. So again, this is inability to detect and review non-decisions. But in those cases where bail was being used, officers described a far greater engagement and reflection on this previously mundane, routine exercise of a power that had quite significant rights implications. This took different forms. So part of it was reflection on, is this power even useful actually? If it's not going to be proactively policed, if it's not an offence, if I don't have the evidence to do anything at this stage anyway, if I was to arrest somebody, why are we doing this actually? Why are we releasing these people with conditions for a long period of time? Like this doesn't make a great deal of sense. The law prompted that reflection that otherwise just wasn't taking place. There's also something here about these inspectors that were reviewing these cases. Custody sergeants live and breathe custody. That's their world. These inspectors, some came from the custody world, many did, but others didn't. And it was bringing in officers with different kind of experience, different rules, injecting a kind of different thinking and challenge into some of this decision-making, coming up with different solutions, sometimes which weren't bail. So it was internally exposing that world to officers from outside it that wasn't previously taking place, when the discussion would never have been elevated up anywhere beyond the desk in the custody suite previously. And also there's a simple point in if you're using power less frequently, if it's less routine and you have more time when you do use it, officers are saying actually it gives us an opportunity to focus our minds much more. Why are we using this? What are we trying to do? And it becomes more significant when you do use it. It's an interesting point there. Finally, the communication systems around this I find fascinating. So there was no reporting requirements in the Policing and Crime Act 2017 as to what police should do about this, how they should ensure they're showing cases are necessary and proportionate. The how they're showing it. Superintendents are signing off on this. It's different now, I'll say in a moment, but this prompted imagination from the police service itself. They created a new team that didn't previously exist called the bail management team. Incredible. They got spreadsheets every morning with the 24-hour bail conditions. They noticed that 50% of those had errors or issues that needed to be rectified. The wrong date had been put on them. The detective sergeant was signed off instead of the custody sergeant having authorized it. They would identify poor or missing rationales. They provide feedback on the poor rationale or necessity of proportionality. They would create a breakdown of how each custody suite was performing in terms of its compliance with the disposal rationale. He had input into police training and force policy on pre-charge bail. They became the pre-charge bail gurus that came with some kind of esteem. They would answer queries from officers. They'd be on the phone. They would be really heavily involved in reviewing the forms that were going to the courts. They would do track changes. They'd have 2 or 3 edits of a form that was going to the courts. There was a bail monitoring team set up that quarterly did a dip sample of cases of release under investigation and bail. Officers from different roles and responsibilities from bail management team, the youth offending team, to reflect on its use. This is as things became more serious. And there's also this creation of a bail authorization form that became known as a BAF. That's what officers talked about. This was an in-house form, completely designed by this force, to try and think about how they were going to comply with this standard. So that included a summary of the case, specific inquiries and dates when the inquiries were expected to be finished, why it was necessary to bail the suspect, what bail conditions were proposed, special parts in the form to fill in the representations from the solicitor. And again, the next page on the form will be where the inspector fills in their bit. So there was this paperwork, this paper compliance. Again, that was nothing required in the legislation, but it was the legislation that prompted them to think, right, we're going to have to set up some kind of machinery to make this work. And then in terms of how it was actually used, paper burden and its relationship with reasoned administration is something I'm thinking through at the moment. But the description was used of building bail, that you work with another officer, applying these principles. And whilst sometimes you could go in with your shift and you build the bail over the course of time in custody, every so often you get a new case inspector or sergeant coming on, and then you have to work through that process again and think about it and construct it. This idea again of the paper and the format actually doing quite a lot of work in the reality of that part. And again, because it was different inspectors being brought into this role, they would engage with the form in different ways. No inspector is the same. No one wants the form filled in the same way, in the same detail, or the same expectations. So again, this in Erickson's words, this idea of communication format and communication rules being kind of played out and having their own kind of structure in the form. Then it all changed, and it turned out the system was indeed failing victims, that they left victims feeling unsafe. Victims of crime put at risk by abandoning bail orders, and we very much saw the victim come to the fore. The significant case in this, the tragic case in this, was Kay Richardson, who was murdered in 2018 by her ex-husband, who was released under investigation with a history of domestic abuse, clear risk to the victim, no bail conditions. And this focused the mind of the Home Office, along with kind of figures about the sheer extent of the reduction in bail, the timeframes. And lo and behold, we had statutory reforms again, undoing reforms that had just come before. So they were scrapped 2 years in. No, not 2 years, but 4 years in. Removing the presumption against bail. Not only, so whereas previously we were concerned about the rights of the person being investigated and we had to seek their representations, now we need to seek the representations of the victim, as the victim's coming in very much to the fore, delivering justice for the victim. We want the victims to view what conditions they would like imposed on this person suspected of the offence. This authorization process completely changed, completely scaled back the decision stays in custody for the first 3 months. It only goes to an inspector from 3 to 6 months. It only reaches the superintendent at 6 months. It only gets to the courts after 9 months. So taking out this kind of internal review responsibility, trying to encourage police officers to use bail, delaying the detention clock if someone's arrested and brought in for a breach of bail, notifying the victim. And crucially, what's happening at the moment is a big drive to collect data on breach of bail, because what the police are pushing for is to make breach of bail an offence. And if they collect the material or if they collect the data on breaches, they're hoping that that will be leveraged to actually make it a criminal offence to breach bail conditions imposed by custody searches. What we're seeing is, fortunately, we don't have the figures for 16, 17, 17, 18 before the reforms, but what we know is that this is a very small number compared with how bail used to be used. This was published last month by the Home Office, the first round of data gathered on pre-charge bail, and it's bouncing back. We're seeing the absolute resurgence of this power again as soon as these legal tests, thresholds, timeframes are taken away. So I'm back in the field again. I'm collecting another 4 years of custody data to have 8 years of data to see how these changes have taken place. I'm going back and interviewing officers again to try and see what's happened and try and get authorization forms. And this has turned into a big thing on pre-charge bail, which I feel now compelled to finish without having really written up anything from the first one yet. Such is work and other things. But yeah, it's turned into a longitudinal kind of project on police force and law and policing. Very briefly, does it require us to reevaluate some of the truisms? Yes and no. No, in that law did change policing, but arguably it can be explained because of the truisms that were mentioned at the start. Erickson, 1981. Police develop strategies to avoid the new rule, to implement it with minimum level of compliance possible, and to turn it to their advantage in the task of easing. In this case, police sought low visibility. There was a culture awareness of trouble. There was a hesitancy to engage with the paper burden, and it challenged part of their police mission, confronted with limits of power to control suspects, protect victims from harm, symbolically and practically. Then we say it's a futile power, it's not worth it anyway. But at the same time, law did change policing practices in ways that can't so easily be explained by this wisdom. The very basis of the reforms were concerned with the rights of the suspect, the pains of legal limbo, a firm legislative steer, rather than trusting the College of Policing that had just been created at the time. A desire to bring high visibility to these powers. And in that sense, it's hard to see how this was due process for crime control in the very devising of this power. The outcome was opposite to that predicted by the likes of Huxley. For good reason, they predicted that. The police the police shied away from this power that was long attractive to them, that was routine, that was mundane, that was useful for controlling suspects, that provided them with de facto investigative timescales. Organizationally, they were strikingly conscientious here to cultivate internal processes and procedures beyond ass covering and managing trouble, to encourage some degree of reasoned administration, justification, consideration of necessity and proportionality. They went beyond what the law required in some ways. They were imaginative in designing a mode of kind of regulatory principles there. And I think that it makes me also think more about the notion of principles-based regulation, something that Ian's written about, the idea that we guide action by underspecifying rather than overspecifying. We create a platform for thinking, creativity, experimentalism, creating BAF forms, creating a bail authorization team, creating a bail management team, participating in it. This space for what Ian described as decentered regulatory spaces that produce and monitor policing practices. And ultimately, I wonder if it was completely the wrong thing to do to take away these police powers as early as they did. I would have been so curious to see another 2 years of those processes in place, to see what would have actually happened with that principle-based system
Thank you very much. We've got 20 minutes or so for questions and comments. So before we can carry on afterwards, but